Welcome to the Life Unlimited podcast with Larry Heller. You deserve complete financial advice so you can confidently live your life your way, for life. Now, let's get into this week's podcast episode.
Hello and welcome to another Life Unlimited podcast with your host, Larry Heller. Today, Douglas Rowe is our guest. He's a seasoned partner at Certilman Balin, specializing in labor and employment law. He is known for his expertise in discrimination claims, wage disputes, and litigation prevention strategies. This is my favorite part. Recognized as a New York Metro super lawyer from 2013 to 2020, he was also awarded the Legal Eagle by Long Island Pulse magazine. Doug actively engages in professional associations, serving on the board of directors of Rock and Wrap It Up, while providing strategic counsel and negotiation expertise to clients to mitigate legal risks and costs effectively. All right, Larry, why don't you take it away?
Thanks, Matt. Thanks, Doug, so much for joining us. I think our audience will learn a little bit today about the employment law. So before we kind of dig into that, why don't we give the audience a little bit of background? Why don't you tell us a little bit about Certilman Balin, the firm?
Sure. So Certilman Balin is one of the largest law firms on Long Island. Among our practice areas are real estate, corporate and M&A, nonprofit, tax certiorari, banking, trust and estates, bankruptcy, commercial litigation, and labor and employment law, my practice area. So it's really a law firm geared towards helping businesses comply with the laws and do whatever's necessary from a legal standpoint.
Great. And then how long have you been practicing as a management side employment attorney?
Yeah, does it really matter how long? But I'll give you just a general number. It's about 40 years, Larry.
Okay. And do you specialize in any industry, size, and I mentioned management side. So why don't you tell us a little bit about that as well?
Yeah, sure. So I don't necessarily specialize in any particular industry because every employer has employees and they all have similar issues, whether it be wage and hour, well, just generally, whether it's they all need to comply with the labor and employment laws. And when they don't, they get the audit letters from the Department of Labor or the federal complaint that has to be responded to. So it's really all industries. We have quite a few companies in the blue collar industries, such as parking garages, car washes, restaurants, hotels, construction companies, general contractors. It's a heavily in the construction field as well. But again, and I collar companies too. I represent law firms. I represent medical practices, et cetera.
Okay. So let's kind of dig into this a little bit. So, what are you seeing as the biggest issues that employers are not protected for? Because obviously you probably get called on after there's a problem, but so what are some of the issues that employers should be aware of that they're not protecting themselves for?
So I see as really the number one issue it's compliance with the wage and hour laws, and it's so easy for employers not to comply because they're just not aware of the law. By way of example, many employers who haven't had an issue with either Department of Labor or an employee claim assumes that merely because they pay an employee on a salary basis, that employee is not entitled to overtime. Well, that's not the law. The employee has to be, if the employee is paid on a salary basis, that doesn't end the analysis. Part of the analysis then is whether the employee is actually exempt from overtime. There are certain limited exemptions, the executive exemption, the administrative exemption, the computer professional exemption, the outside sales exemption. So there are other exemptions. So it's not only a salary test, and the employer has to reach the salary threshold to pay the employee enough money to reach the threshold. And even if the threshold is reached, the employee then has to perform the duties to satisfy the exemption. So it's a complicated area. And again, there are new laws. The salary threshold goes up every year, just like the minimum wage has been going up almost every year for the past several years and will continue to do so going forward. So it's
You mean,
about,
wait a minute, I just want to stop. So you mean the salary threshold to determine whether they're eligible for overtime or not?
yes. So if there's a manager, if the manager earns $50,000 a year, but the salary threshold is $67,000 a year, even though that person is a manager and may fall within the executive exemption because they're not paid enough money, they don't reach the full salary threshold, then they're still going to be deemed to be non-exempt, even though they arguably fall within the executive exemption. So what happens is if they're non-exempt, for whatever reason, whether it's they don't satisfy the duties test or they're not paid enough money for the salary threshold, then that employee is going to be entitled to overtime wages for all hours over 40.
Yeah. So how can employers protect themselves from this? How do they find out? How do they protect themselves so they don't have to, go through a lawsuit?
Well, yeah, I mean, aside from calling their friendly employment lawyer like me, really they need to have somebody who's on top of these laws, whether it be an in-house HR director or an outside HR consulting firm. It's really a technical area, and it's almost impossible, again, for employers to keep track of it all unless they have somebody like the outside HR consultant or an employment lawyer who they regularly consult with. Because the risk, by the way, the risk is so significant if they're not in compliance. Whether it be for the unpaid wages, and then on top of it, if there are unpaid wages, it's liquidated damages on top of that, which is double damages based upon the amount of the unpaid wages, and then it's attorney's fees on top of that.
Yeah. So why don't you give us an example of, of somebody that thought they were fine and all of a sudden they're now left with a large bill, because you're saying it could be very large.
Yeah, it could be very large. Recently, we had a U.S. Department of Labor audit where a client was accused of not paying the proper wages from an overtime standpoint and also from a immigration law standpoint, because they had many employees here on certain work visas and they didn't pay the proper wages. And the Department of Labor audited and they found liability to the tune of 1.1 million for unpaid wages. I'll give you another example also. Most employers, virtually every employer in New York State was not aware of this law, but there's a law in New York that requires employers to pay their manual workers on a weekly basis. That law has been on the books since the mid-'80s. About 5 years ago, there was a court decision in the first department in the courts in New York, which held that if you pay a manual worker on a biweekly basis instead of a weekly basis, the employer owes the full amount of the late payment in liquidated damages. Every other check is late because you paid biweekly instead of weekly. So basically, the employer will owe that employee 50% of the annual salary because they paid biweekly instead of weekly. And there's a 6-year statute of limitations, so they would have to pay 6 years worth of damages. And if they have 250 manual workers, we had this case, it was in the millions, where the liability was potentially in the millions. So what's interesting about that issue now is that was based on one court decision, but there was another court decision that came down about 2 months ago, which held just the opposite, and that's in the second department in New York. So now we have competing case law. The first department says there are damages. The second department says there are no damages. And we're waiting for the New York Court of Appeals to make a decision on that, and that could be a year or two away. There's also pending legislation. It hasn't been signed by the governor yet, but the governor may do away with the liability for paying on a biweekly basis instead of a weekly basis. But we'll have to see how that goes. But again, these are the type of issues that we come across. Again, the smart employers will bring us in to do a self-audit to identify these minefields that, are out there.
Right, I was just gonna get to that, but we started to talk about New York, so I just want to make sure for our listening audience, because not everybody is from New York. We're really talking about New York law, not federal law, correct?
Yes, we're
Okay.
talking about New York. Yeah, but every state is different. Every state could have their own unique, employment laws.
Yep. So you said kind of a self audit. I was thinking, HR. Is there like a number of employees where you kind of say, "Hey, you've hit this number that you should do this"? What do you think about that?
Well, first of all, I don't think there's a number of employees where you should do this, because the cost involved in doing a self audit is not that significant. It's a few hours of time. We'd review, an employee handbook. We'd review the payroll practices, and we would just have a general discussion on, employment practices in general. So it's not that significant. When it comes to the number of employees, what I have seen is the larger the employer, the more likely that they're going to have a full-time HR director who's
Mm-hmm.
handling matters like this. So, but maybe 50 or so. And once you reach the 50 employee threshold, different laws apply as
Mm-hmm.
well, under such as the Family and Medical Leave Act. FMLA applies to employers with more than 50 employees. Um, and then you have another law like the WARN Act applies to employers with more than 100 employees, unless you're in unless you're in some states which have mini WARN Acts, which apply to employers with 50 or more employees. So
Right. So basically, what you're saying it's spending a little bit money now to do a self audit can save you thousands, if not millions of dollars later on.
that's right. And what's interesting is, in certain industries like the restaurant industry, I have found that the only employers that are in compliance with the wage and hour laws are the ones that have already been caught, audited, or sued, and
Hmm.
then they clean up their act. Otherwise, historically, most employers did things a certain way, and they haven't changed unless they had to change, because they weren't aware they had to change. So,
Mm-hmm.
that's what I've seen. So again, yeah, the smart employers will bring us in to do that self audit.
Okay. So let's talk about some of the things that you may be seeing as a potential employment law issue in the future.
Yep. So it depends on how you define future, because I could talk about short term. 2024, for example, a lot of employers are contending with back to the office.
Hmm.
Um, it's more of an HR issue than a legal issue. But because a lot of employers have the employees are now used to working from home or working on a hybrid schedule, 3 days in the office, 2 days at home. So, there are certain employers in certain industries who are mandating, albeit, slowly, trying to get their employees back to the office. So I think that's a big issue. And how you do that, and at the same time retain employees, because employees are now used to this hybrid schedule. So if employees are um, you know that interested in having that type of arrangement with the employer, if they don't like the mandatory return to work scenario, then they may just leave for another employer that does have that that hybrid schedule. So it's a real issue, but it's more of an HR issue. Um, I think another big issue um, in the immediate future is really workplace culture. And this also goes to retaining employees. First of all, bringing in the right employees, and also retaining employees. And it's really, a science, from an HR director. I think there's a lot of this is going to entail a lot of deeper training for HR people to ensure that the workplace culture,
Mhm.
works with the mission of the employer to make sure that the employees are engaged and the employees are performing as they should, and the employers have also a work-life balance, but at the same time you want to make sure that they are happy and they want to continue to be employed for the employer and do the best job possible.
Yeah, but how does the culture in doing that impact kind of, employment law?
How does it impact employment law?
Yeah.
Employment law. Well, I think that it's about well, first of all, it's about motivating employees to ensure that you get the maximum performance from them, and you don't run into discrimination issues,
Hmm.
because if you have workplace culture issues, then you may have employees who feel that they've been treated unfairly, and they've been treated differently from other employees. And we've seen a exponential growth in discrimination claims over the past few years as well, for based on disparate treatment. And
Nothing
again,
to do with age or gender, just basically different treatment for different people. People are filing claims.
yes, and again, it's based on it. It could be based on age. An older employee claims that the employer permitted a younger employee to work from home and didn't permit the older employee to work from home. Could be
Yeah.
based upon race or sex or national origin or disability. A lot of
Right.
disability claims, by the way, and that there was a explosion of disability discrimination claims during COVID, because that went to the work from home issues. A lot of
Mhm.
employees were claiming that they should be entitled to work from home because they have a disability, um, for whatever
Mm.
reason.
Yeah. So two of the things that I've come across here that I think some small business owners may want to know a little bit more about. But one of them is when you're hiring somebody now in New York State, and correct me if I'm wrong, Doug, that you can't ask them any longer what their current salary and income is. That correct?
That's correct. Yeah, that law went into effect. I think it was last year. It was actually in effect um, originally maybe 2 years ago in New York City, and then it expanded to New York State, statewide. And yes, that is the law in New York, and many states are dealing with salary transparency law, and that was intended to basically playing field from a pay equity standpoint.
So I mean,
Uh,
it's probably a little earlier, but have you seen any lawsuits about that yet, or still a
I've
little
seen
too?
some, yeah, I've seen some claims. Yes. Um, there hasn't been an explosion of claims, but because they're actually filed more on the administrative level, uh,
Mhm.
it could be with for example, New York City Commission on Human Rights or the New York State Division of Human Rights. I haven't seen many before the Federal Equal Employment Opportunity Agency, but they're going to come. But yeah, there have been some cases.
Right.
Yeah.
And the other one, when I talk to other small business owners, especially if they have an older employee that is not kind of, in their opinion, working the same, and they're thinking about terminating that, just how do they go about and protecting themselves?
Yeah, so the best way to protect themselves is to treat that employee just like you're treating all employees, and just focus on the performance. And if they're not performing properly, then write them up, issue warnings. Sometimes it's easier to identify the performance problems. For example, if a salesperson isn't meeting the sales quotas, that's an identifiable issue. It's not always that simple, though, because if you're just dealing with an employee who you feel is not performing at the same level as another employee, it's not always so quantifiable. So really, if there's an attitude issue, if there's a insubordination issue, if there's an attendance or lateness issue, you just write up the employee for whatever performance related issues.
So you would if you're a business owner and you're thinking about doing that, you would suggest they reach out to you to get guidance on how to handle this before
Yes.
doing anything.
Yeah, I mean, basically, when it comes to discrimination, the way the law is set up is that the employee makes the claim of discrimination. The burden of proof then shifts to the employer to articulate a legitimate, non-discriminatory business reason. Usually, they can do that by just saying it was a performance issue, but performance defense should be sufficient documentation showing that the employee was warned, the employee didn't perform, the employee didn't receive bonuses for the last couple of years because of performance issues. The employee didn't receive salary increase over the last several years because of performance issues. So yeah, it is a process, but yeah, it makes sense for an employer to strategize with outside labor counsel or an HR consulting firm to make sure that they're handling these issues.
So if an employer would be faced with some type of liability because they haven't complied with the laws, what can you and your firm do about that?
If the employer is faced with liability, well, first of all, if they're faced with liability and there is a claim, some employers may have insurance to cover those type of claims. There's something called EPLI insurance, Employment Practices Liability Insurance. So if there is a claim, they should check with their insurance broker to see if they have insurance to cover those type of claims. If they don't, and there's an actual claim, whether it be an agency claim before one of the state agencies or a federal or a state or federal lawsuit, they're going to have to hire counsel to defend the cases. And oftentimes the claims are indefensible. The employer, for example, didn't keep track of the employee's hours. The employer has the record keeping requirement to keep track of an employee's hours. And like by way of example, by applying my example before, if the employer assumed that the employee was non-exempt because it was a manager, again, if they didn't reach the salary threshold, then you could have an issue as to whether the employee would have been entitled to overtime. But if the employer doesn't keep track of the employee's hours, whatever the employee says were the hours is really going to govern the case. So again, if the employer is faced with that type of claim, we can come in and help defend it. And if it's indefensible, we can help them reach, a settlement that will be advantageous to them and, avoid, the significant liability.
Doug, anything else that you wanted to mention today you think would be of interest?
I did actually. When you asked me before about what I see in the future, I talked about the short-term future when I mentioned back to the office issues and workplace culture. But everybody is talking about AI, and AI is a big issue in the HR world and in employment law. And in fact, New York City has enacted I think when it came out, it was actually the first in the country law. But basically, if employers use AI in hiring decisions, there has to be a bias audit that's conducted, I think, annually to make sure that the AI that they're using to basically review resumes and weed out employees is not in and of itself biased. So, if the AI software is set up to weed out certain employees of a certain age, for example, that would show up in a bias audit. So it's really another way to, and by the way, there are employers that literally have received thousands of resumes a week. So they have to have that kind of software to enable them to properly hire and review resumes. So, that's a big issue, and that's
Yeah,
going
I
to be,
think AI is going to change the world in a lot of different
it is,
ways.
and it's going to be
So,
a big issue in every state going forward, Larry.
yep. So Doug, this was great. So if anybody needs to speak to Doug or has a question for Doug, where can they reach you at?
They can reach me at my law firm. My email address is drowe, DROWE, at certilmanbalin.com. And my office phone number is 516-296-7102. And they can always reach out to you, Larry, because you have all that contact information from me. Doug Rowe.
Absolutely. So, Doug, this has been great, and don't wait until you have an issue on the employment. Speak to Doug. Speak to someone beforehand that can help you prevent some of these issues.
And I have one last takeaway, Larry. Many employers have said to me, and I think it's great advice, that they don't terminate an employee without consulting with their employment lawyer.
Yeah,
Yeah.
great advice.
Yeah.
Yes.
And with that, everybody, listen, here's the long and the short of all of this. Listen, I know that there are listeners to this podcast who work with other and have friends who are business people across not only New York, but also all over the United States. This is a perfect podcast for you to share with them because they covered so much wonderful stuff that's so vital for you as a business owner, as an entrepreneur. So for Larry Heller, this is Matt Halloran, and we'll see you on the other side of the mic very soon.